Good morning. Can we bring the room to order? I was just apologizing on a college campus. 9 a.m. is not an ideal start time. Can everybody hear me okay? Great. So just like the trains in Mussolini's Italy, we're going to try to run this thing on time and get started. We've got a lot to do today. So I'm Steve Slick. I'm the director of the Intelligence Studies Project here at the University of Texas, which is really a great privilege. I've met many of you, but not all of you, and so come up and introduce yourself and get acquainted with me and the program. And so get settled in. If everybody has a schedule, a cup of coffee, we'll get started with the morning session. So first job is to welcome our conference participants. We realize you're all extremely busy, accomplished people. You could be doing other things, but most of you took the time to travel from Washington, and we're very grateful. I'm sorry about the promise of good weather. We didn't deliver on that, but the food is good and the company is good, and I think we're going to have an entertaining day. What really brings you here, though, and I understand from talking to a number of you, is not just the opportunity to visit Austin, which is notable, but also the fact that you care about our national security. You understand the role that U.S. intelligence plays in keeping the country safe. And also, a number of you have expressed interest in the topic that we're addressing today, and that's how we nest the world's most effective intelligence enterprise into the world's most advanced democratic society. And you know we've had some challenges with that over the last few years, so I think we've got a particularly useful topic. I also want to welcome our student and faculty counterparts from other UT system institutions. We have counterparts here today from University of Texas El Paso, University of Texas Dallas, and the University of Texas Rio Grande Valley. So welcome. Many of you know, some of you may not, that our chancellor, who apologizes, he wanted to be here but was unable to be, Bill McCraven, has charged us with stitching together our national security programs around the UT system into something he's called the UT National Security Network. So I would encourage you to think about this as a down payment on the kind of event, the kind of experience that we want to organize within that UT network for national security. Welcome also to our students, faculty, colleagues, and members of the Austin community. I should note that we have co-sponsors for today's conference, the Robert Strauss Center for International Security and Law, Clements Center for National Security, the LBJ School of Public Affairs, Center for Politics and Governance, and the UT Student Veterans Association. So we thank all of you for the support. Special thanks also to the staff of the Strauss and Clements Centers. They do an absolutely extraordinary job putting these events on, and if you see them throughout the day, please say thank you, because we really appreciate what they do. So when I was considering yesterday how I wanted to very briefly frame the topic of this conference and today's conversation, I was somewhat taken aback when I looked over at the conference poster. You may have seen one outside, and I realized several months ago when we were doing the marketing planning for this event that we'd chosen a topic, intelligence in American society. And after I watched the morning news on my way in today, I thought we should probably come in and put a question mark at the end of that and probably have an entertaining discussion. But there it is, intelligence in American society. But seriously, you know, one of the goals we've set for our intelligence studies project is to merge our academic coursework, the courses and seminars at the graduate and undergraduate level that we offer to our students, together with research that's relevant to people in Washington in the intelligence field, and finally with conferences and public events like this one. And so this is a pretty good example. At least it's our first try at this. So Professor Will Imboden, who's here somewhere, I think, or just outside, and I are teaching a graduate school seminar. It's called a professional research project at the LBJ School of Public Affairs. We have a dozen or so really terrific students who are studying the topic of supervision and oversight in American intelligence, okay? And you're going to hear from them after lunch. They're going to tell you a little bit about their project. And the goal of their year-long course is to produce a report that will address how effectively we're supervising and overseeing our intelligence community. It will also include some recommendations. And our client for that report is the Office of the Director of National Intelligence. And so that's about as policy relevant as we can get. And then we've brought together this distinguished group today of practitioners, current, former officials, journalists, and so now we're going to discuss it publicly. So that's the way we've tried to stitch this all together. Now, the objective of the course and the objective of our discussion today is to consider the full range of individuals and institutions that play some role in ensuring that our intelligence activities are lawful, effective, and broadly consistent with American values. So we've organized 4 panels today. The first panel will consider how the executive branch polices itself. The second panel will consider the role played by the relatively young Privacy and Civil Liberties Oversight Board. After lunch, we're going to have a discussion with Chairman McCall and Chairman Conaway about legislative oversight of the intelligence community. And finally, we'll wrap up with what we hope will be an entertaining discussion concerning the role of the media in covering national security affairs. So to kick off today's session, I'd like to invite the group up to the stage, and I'll introduce the moderator, Philip Bobbitt, who scarcely needs an introduction here in this crowd. But in any case, I should caution that folks should check your egos in terms of participants here in the conference. The introductions are going to be very spare. There's a biographic packet that in the materials outside. So if you're interested in learning more about one of our participants, just take a look at that. Everybody here is very accomplished, has held a number of jobs, and we're not going to plan to review them in detail. So Philip on my right is, of course, a highly regarded scholar and author, currently holds the Herbert Wexler Chair in Federal Jurisprudence at Columbia University. And for today's purposes, you should know that Philip has also served in the White House Counsel's Office and in the National Security Council, overseeing intelligence activities. And most importantly, he happens to be our friend, neighbor, and colleague here in Austin. So I'll turn it over to you, Philip. Thanks.
In 1937 and 1939, the Supreme Court handed down a pair of decisions in Nardone versus United States. The court held that the Communications Act of 1934 barred the federal surveillance of telephone lines without a warrant. Nevertheless, in 1940, President Roosevelt authorized a program for the surveillance of communications to preclude espionage and sabotage within the United States. In a memorandum to the Attorney General, Robert Jackson, FDR distinguished Nardone's application to intelligence surveillance as dictum, I'm quoting, and he directed Jackson to resume the surveillance he had ordered stopped after the Supreme Court decision. The president then sought statutory language that would have authorized surveillance and collection, but when the Congress and the White House were unable to agree on compromise language, FDR simply continued the program. This historical incident is only one signpost along the path our country has taken to bring national security procedures under law. This is not easy. Much of the work of the government in this area must be secret, although we live in a democracy that depends upon a fully informed public. Some of the collection efforts abroad are illegal in those jurisdictions, yet we aspire to an international society governed by the rule of law. This morning we have 3 distinguished persons to discuss the problem of executive branch supervision of the activities of the intelligence community. The public, I know, is well aware of legislative oversight of the community, but less so, I think, of the many layers of oversight and supervision within the executive itself. As our friend Sam Raskoff at the New York University School of Law has recently reminded us, in the Harvard Law Review, one of the consequences of the Snowden disclosures has been an increased demand for collection oversight, including oversight by the president. But so much of this oversight is secreted in the daily flow of tasking, decision-making, and after-action reporting that very few outside a quite limited number of persons in the White House or DOJ or CIA can actually know and appreciate the extent of executive supervision. I'm sure that's why Steve Slick has induced our 3 respondents today to come to Austin. We have a senior director from the National Security Council, the former executive director of the PIFIAB, the President's Foreign Intelligence Advisory Board, a former general counsel of the FBI and assistant attorney general, and we are very happy to have them here. Our format will be first a series of 10 to 15-minute presentations by each member of the panel. If appropriate, I may ask a question from the chair at the end of each presentation, but I really want to reserve the bulk of the time for questions from the floor. We'll begin with Brett Holmgren, then go to Ken Wainstein, and finally Joan Dempsey. As Steve said, their biographies are in the program, so I'll conserve time by simply saying how very proud we are to have them here in Austin. Brett.
Thank you, Philip. Thank you, Steve, and to the University of Texas for hosting all of us here today for what is a very important topic, not only to our national security, but also to our democracy. In a few hours, you will hear from my mentor and the President's Homeland Security Advisor and Counterterrorism Advisor, Lisa Monaco, and she's going to walk you through kind of the broad approach that the Obama administration has taken to intelligence oversight over the past 7 years. And so, without stealing her thunder, I'm going to describe and offer some thoughts on the process, and in doing so, hopefully shed some light on what that looks like in practice. And I'm going to keep my remarks fairly short so I don't put all of you back to sleep so early in the morning. At the outset, let me just say that intelligence oversight has never been more important than it is today. The threat environment that we live in is unprecedented in modern history, from new challenges like cybersecurity to old but evolving threats like North Korea. The increase in the threat environment also places an increased demand on our intelligence community. Now, with this demand, it also demands that we have oversight structures in place to evaluate not only are the intelligence operations and activities effective and consistent with our values, but that privacy and civil liberties have been appropriately protected, and importantly, that the public has trust and confidence in them, because ultimately our intelligence community and the activities they conduct exist to serve the American people and to keep us safe. Now, while the oversight structure that Philip referred to briefly has evolved most significantly since the 1970s, there's a common tension that has endured, and that is between democratic governance and accountability on the one hand, which requires openness and transparency, and intelligence oversight on the other, which by its nature requires secrecy. So the challenge we have long confronted, and I think we continue to confront today, is how do we ensure that the intelligence community has the tools, the capabilities, and the authorities they need to do their jobs and to keep us safe, while at the same time subjecting their activities to appropriate oversight and a systems of checks and balances, again, to ensure that not only they comply with the laws, but also that the privacy and civil liberties of all Americans are protected. So what is President Obama's approach? What does the administration's approach to intelligence oversight look like? He has demanded that we take the same approach to oversight that he demands we take to all national security challenges. And in 2009, he said, and this sums it up, we will constantly evaluate our approach, subject our decisions to other branches of the government as well as the public. So that is the charge he has given us, and that is the charge we have tried to faithfully execute. In that connection, I think it's worth noting that the intelligence community today has more oversight by all 3 branches of government than any other intelligence service in the world. And I think that's a credit to the nation and to the branches of government that conduct those activities. Now, within the executive branch, there are multiple oversight mechanisms. You have the inspectors general. In the intelligence community, the various agencies. You have, of course, the Office of the Director of National Intelligence, the Department of Justice, and of course, the White House and the National Security Council staff, which provides policy oversight. So what does it look like in practice? Well, there's no one-size-fits-all, and frankly, it depends on the situation, the topic, the operational proposal, and so forth. But over the last several years, we have increasingly relied on the kind of established interagency review processes and mechanisms that we conduct much of our foreign policy and national security deliberations. So these include deputies and principals from all departments and agencies, or relevant departments and agencies. And the reason we've done that, and the reason the President has placed an emphasis on that, is to ensure that senior policymakers are involved in intelligence collection decisions, operational decisions, not only that they are aware of, but that they are also accountable for the decisions that we make. Outside of the established interagency processes for reviewing certain proposals, we of course have less formal but equally rigorous mechanisms. The intelligence community chiefs, particularly Director Clapper and CIA Director Brennan, and their deputies have regular interactions with the leadership of the National Security Council. There are also standing meetings between intelligence community chiefs and National Security Council leadership to review operational proposals, to discuss what the implications of those may be. And at all turns, there are multiple opportunities to ask questions and to bring in other agencies as appropriate. But we also know that more oversight does not mean better oversight or more effective oversight. And so we have taken a careful approach over the last several years to ensuring that the appropriate trade-offs and considerations are included as we evaluate and consider these operations. We have taken a very clear approach to gathering a variety of inputs from departments and agencies to weigh the pros and cons, to identify what the trade-offs of certain operations are, and ultimately to ask ourselves, are we conducting the activity because we need to, and not simply because we can? So what is that? What are the various factors that we consider and that we weigh when we are discussing these proposals, collection activities, operations, and so forth? One, first and foremost, is it legal? Secondly, have privacy and civil liberties been appropriately protected? What are the risks to our diplomatic, law enforcement, and intelligence community relationships if the operation were disclosed? What are the trade, investment, and economic implications of certain activities? What are the beyond the privacy implications, what are the trade-offs and risks from a policy standpoint associated with the proposal? Is it consistent with our policy objectives and our strategy? And finally, is it wise? So these are sort of a range of factors that we will apply on a regular basis as we, as an interagency, and the leadership of these agencies are considering and exploring and discussing and debating and challenging the validity and the need for certain operational activities. But it's not just inside the executive branch or just internal to the NSC or to the White House. We also rely certainly on outside groups as well, such as the PCLOB and Dave Medine and his folks, certainly the President's Intelligence Advisory Board and the Intelligence Oversight Board. As appropriate, we will rely on outside groups such as the Review Group for Communications Technology that President Obama directed in the wake of the unauthorized disclosures in 2013, and of course on our congressional oversight committees for ideas and recommendations. So let me conclude just by noting that I think given the challenges going forward and given the rapidly evolving threat environment, I think it's going to be critically important that our oversight structures, not just in the executive branch, remain nimble and flexible enough to keep up with the intelligence agencies that they are designed to oversee. And I am optimistic that the processes and the procedures that this president has put in place can endure for future administrations and provide a framework to evaluate and to consider the very real consequences as well as the very real opportunities inherent in many of these intelligence activities. Thank you.
Thank you, Brad. I just have one question for you, then we'll go to Ken. After the disclosure of the cell phone intercepts of Chancellor Merkel, it was often proposed that there be a New York Times test. I know Eric Schmidt is here today. We'll get him to react to this. And the test is, if you can't bear seeing it on the front page of the New York Times, don't do it. Is that really a good test?
If it's a good test, it's a useful factor to consider. And it's certainly something that is discussed in these meetings. We don't apply sort of New York Times tests to everything, but again, we have to be asking ourselves, is the value of the information that we are seeking to collect, does it have policy value? Of course, there's a difference between policy value and intelligence value, and I think the one thing we have seen over the last couple of years is placing an emphasis on, do we need this information? Can it come from other sources? Are there other ways to get at the same pieces of information that we're trying to collect? Are there smarter ways to do it? And of course, does it need to be conducted by the intelligence community?
All right, thanks. We're going to go to Kenneth Wainstein, a very distinguished lawyer. As a law professor, I'm always happiest when I'm on a panel with lawyers.
Okay, good morning, everybody, and thanks for including me in this. And Brett, I think that was an excellent overview. Maybe a little too excellent. I'm going to tell Lisa you totally stole her thunder, but I think it actually was a very good starting point for us to sort of get an understanding of where things are now. And keep in mind, my views are a little bit dated. I left government in 2009, and so I see things from a different perch now. There are a number of ways I keep myself involved in the intelligence community, but I think it's really important to hear from the current administration, be it this administration or the next administration, on a regular basis about what's being done with oversight, because that instills confidence and protects against an erosion of confidence when things come out in the press that might suggest that things are being done inappropriately in the intelligence community. The more that the executive branch is out talking about what they're doing to ensure proper conduct, the better. So I applaud the members of the administration for being here today. I want to sort of take a look at the spectrum of things that can be done. Step back for a second. If what we're trying to do here is look at oversight of intelligence operations and think about and assess what can be enhanced, what can be done better, you really have to look at the whole spectrum of activities that I think feed into effective oversight. And the spectrum runs from oversight at the individual level, in other words, the individual operator, individual agent, individual case officer, who is going to regulate himself or herself. From there to the attorneys who are in those divisions, in those agencies, who are embedded there working with those agents, operators, et cetera, to the inspectors general of each agency, who are of the agency but really, for all very good reasons, stand a bit apart from the agency, to the IOB and to the NSC process. So you have that whole range of executive branch oversight mechanisms in place. And I want to focus on the first part of that range for a minute, because I think that's something that's often forgotten, or at least not sufficiently appreciated when we're talking about oversight. We often think, and I fall victim to this, okay, we need oversight, that means we need more eyes looking down. Just as importantly, I'd argue even more importantly, we just need more eyes and better trained eyes looking in at within the operator himself or within the agency in the person of really strong attorneys who are looking out to make sure that safeguards are being protected, et cetera. So that breaks down for me into kind of two things I want to address today. One is, what is the state of training and sort of the building of a culture of observing limitations, civil liberties, and privacy within each of the agencies in the intelligence community? And the second, the role of attorneys. So just to start with the first, and I'm not saying anything terribly profound, but I've worked, I had the pleasure to be a federal prosecutor for many years, and I worked with a whole range of law enforcement agencies, police departments to the DEA to the FBI, and then once I started working with the intelligence community, the NSA and the CIA. And one thing that's clear is there's a different culture in every one of those agencies, and there are a lot of ingredients that go into culture, right? Mission, hiring practices, tradition, history, all these things. But a very important part of it, though, is the training that is given. I mean, not just the onboard orientation training, but the training and continued guidance that is given to personnel throughout a person's tenure in each of those agencies. And you get a different feel for each agency. And that, to me, has always emphasized the importance of that training, that we need to make sure, when we're sitting here looking at oversight, we need to first go back to kind of first principles. What are we telling people they can and can't do, and what they should do if they have doubts? And how are we sensitizing our people to look for those question areas? How are we making sure that when they hit a delicate point, they know to ask the right question or to elevate the issues? That's critical. And I don't think I need to say much more about it other than that this is something that we need to consider whenever we're looking at the efficiency of oversight. And the best anecdote I have that I think highlights this goes back to 2002, 3, 4 era, when at that point it was the time of the 9/11 Commission and the country was struggling with how we can reform the intelligence community to better anticipate and stop the next 9/11 attack. And you remember a number of people were opining that we needed to adopt an MI5 kind of construct where we took the FBI and bifurcated it and separated out the domestic intelligence part of the FBI from the law enforcement part of the FBI. And that actually got a lot of traction. A lot of people were looking at it. Ultimately, the 9/11 Commission decided not to recommend that for very good reasons. But I think an important thing that I learned from that was one of the FBI's, I was the general counsel and chief of staff at the time of the FBI, one of our strongest allies was the ACLU, opposing the MI5 recommendation. And the reason was that Tony Romero and the ACLU recognized that it was much better to have that domestic intelligence collection responsibility in the hands of FBI agents who have strict training about guidelines and limitations and how law enforcement should be conducted than in the hands of somebody else. Now, different people agree or disagree about the wisdom of that, but I think it was a valuable lesson to me in the value of that kind of training and that culture. So, point being, we should focus on that, and to the extent that certain agencies have very good training, those best practices should be shared. The second point I want to focus on is the role of attorneys in intelligence operations. And for this, I want to point to my friend David Criss, who is the Assistant Attorney General of National Security, who's written the book about FISA. And he talks about this as, he uses the term intelligence under the law. And he talks about since the 1970s how there's been the construct of the construction of this oversight infrastructure, but a very important part of that has been the insertion of attorneys into operations in the way there weren't before. And it's true, up until the 1970s, there were relatively few attorneys sort of working hand in glove with intelligence operators. And I think the best example of that was the FBI. I don't think the OGC existed until sometime in the maybe early 70s. And I heard a story, which I don't think is apocryphal. I think it's actually true, that the only reason that Hoover decided to set up the Office of General Counsel was he wanted to make sure that he had some agents who would chaperone the DOJ attorneys when they came over to ask questions about their intelligence operations. That was the original purpose. But I think what we've seen is more and more lawyers, and while some would say that gums up the works or has the potential for gumming up the works, in my experience, it's actually been the opposite. And throughout my career, I've seen that at every step. I was a line prosecutor. Actually, Lisa Monaco and I were sort of talking in a self-congratulatory way last night about how great it was to have been a prosecutor. But, as a prosecutor, what do you do? An agent comes to you and says, hey, we want to, take this step, do this search. Can we do it? As a prosecutor, you have a dual role. You're looking at that issue from the perspective of, I want to advance law enforcement, I want to catch the bad guy, but you're also looking at it from the perspective of, can we do that? Are the limitations in place that we have to observe? And so you're instilled with the duality of that role very early on. I saw that playing out with FBI OGC. It was staffed with a lot of agents who loved to kick down doors and loved to get the bad guys, but they recognized their role was to make sure that it was being done according to the rules. NSD, the National Security Division, where I was the Assistant Attorney General, had always had that role in the relation to the attorneys who helped the FBI agents go in and get FISA orders. Played that dual role, helping them get the authority, but also making sure that we had the necessary predicate. That got expanded over the last few years to actually have broader oversight of FBI operations. And I've also seen that with the other agencies I worked with, the CIA, NSA, and the like, where you've seen over the last 10 years more and more attorney involvement in operations. Just to conclude, obviously, that has a potential downside. It can gum up the works if you don't have the right approach. You have to have a can-do approach as an attorney in that capacity. And also, it can, attorneys can become almost captive to the mission. And you have to maintain that distance from the mission. Difficult balance to strike. I know I've talked to the CIA, the last two general counsels about that issue, about embedding attorneys in the operational units and how long you should keep them there and whether you should bring them back to make sure that they don't get sort of captive to the mission. In other words, lose their kind of regulatory legal perspective. Those are manageable issues. They're management issues that can be handled. But I think that, as that second piece of my recommendation would be, whenever thinking about oversight, don't just look at the external functions, external to the trenches, to the operations. Look at the internal, because that's really where you get the biggest oversight bang for your buck. Because if you can enhance the culture, enhance the training, enhance the legal oversight within the within the operations, you're actually going to make strides that you wouldn't be able to do from the outside.
Thank you, Ken. That could serve as a kind of an overture for the whole conference, because I think particularly the public is more inclined to look at external supervision and maybe not to appreciate how important the culture is of the people on the ground. I was quite struck by your emphasis on these cultures. The CIA culture and the FBI cultures are often portrayed as being so different they'd be a good source of a sitcom. And I want to just ask you to deal with the merits of the MI5 proposal, because people who were urging that hiving off of the intelligence function were people who were also concerned about culture. And they, I think, said that the culture of prosecutors, of law enforcement, and of crime detection is a very different culture than that of intelligence collection. What do you think about the MI5 idea, just on its merits?
That's a great question, and I think I wrote more talking points about this issue than I care to remember. That was, as you can imagine, that was sort of an existential threat to the FBI at the time. And the director made it very clear that we needed to win that war, and we did on the merits. And it wasn't we. I just think the country came to the right result. Look, I get why people looked at it. You had a failure to connect the dots, and that failure was intelligence community-wide. This is pre-9/11 that led up to 9/11. One of the problems was that the FBI was too law enforcement oriented in its approach. That's the way it had always been, and it had intelligence components, but they were subordinated in every number of ways to the law enforcement components. The people who rose to the top of the agency tended to be the law enforcement folks. They got the attention, they got the glory, et cetera. I'm speaking in simplistic terms, but there are a number of reasons why the intelligence capabilities of the agency were not put front and center for development, and that was one of the factors that led to the failure before 9/11. So people were screaming for some kind of way to address the problem, and they looked at this MI5 idea, and some would say that it works okay in other countries. Others, the Canadians expressed to me that it was a real problem. The main arguments for it, I think, were the one that you just cited. That look, you get a dedicated group of people who are just out to collect intelligence, get indications that there might be a plot, afoot, and just do that. Not worry about statistics of arrests, pursuing bank robbers, this kind of thing. The other argument, the one that prevailed, is, well, actually, that goes directly contrary to what we're trying to do post 9/11, which is integrate and harmonize the operations of all of the U.S. government and its assets, its counterterrorism assets. So get the FBI's law enforcement agents working closely with the intelligence agencies so that you can share the information that those agents are getting with the intelligence agencies, and all work as one whole as opposed to being bifurcated. So this was going against that drift and or that conscious effort by the government to try to integrate all its assets, which has been, I think, a profound success ever since 9/11. But also, look, the best argument, I think, against it was, don't you want, when you're talking about an FBI agent operating domestically to try to find a bad guy, wouldn't you want that person to have within his or her toolkit the ability to develop that somebody as an intelligence source, in other words, intelligence tools, but also the ability to use law enforcement tools? Because one of the best ways of developing information, in my experience, is arrest somebody, tell them that they're going to be facing X number of years in jail unless they cooperate, they tend to want to give you information in that situation. If you don't have the ability to arrest them, you don't have the ability to make that threat, then you're not going to get that. So that argument that it's better to have all those powers in the domestic agency that is focused on counterterrorism ultimately prevailed, and I think history will prove that that was the right call.
Thank you, Ken. I know all of us are, at the top of our agenda now, are worried about cybersecurity and the protection of our critical infrastructure, but this audience probably knows that this is not a new subject. And in the late 90s, some of the most interesting and the pleasantest times I spent worrying about critical infrastructure were when I got to see Joan Dempsey out at the agency, who's really been a voice on this for quite some time and one of the country's great assets. Joan.
Thank you, Philip. I think you've lived a very boring life if that was one of your most enjoyable experiences. I'm delighted to be here this morning. I think it's a really important topic. Before I make my comments, though, and I'll fully acknowledge that I intend to be a little contrarian on this topic, and I'll explain why, and then we can certainly have a discussion about it. I want to react to something that Ken said, and I was involved in those discussions about what to do about domestic intelligence and law enforcement after 9/11. And again, taking a contrarian view, I believed that arresting people based on intelligence collection in this country was counter to democratic principles and the rule of law. That you arrest people based on suspicion of illegal activity, not on intelligence, which the very nature of intelligence collection is to try to identify issues and problems, and then you take it into other venues to determine whether you actually have illegal activity. I don't want the people who are collecting the intelligence to also be able to make arrests. I still believe that today, lost the argument, obviously, and I'm not saying that keeping it together was wrong. I'm saying that the debate never really rose to that level of discussion. Do you give arrest powers to people who collect intelligence? I just disagree on that point. But to be contrarian, to continue this idea of a contrarian argument, we have an enormous amount of intelligence oversight, as my esteemed colleagues have already said, both inside the intelligence community and the executive branch, but exterior to it as well. And that intelligence oversight performs a very powerful benefit to a democratic society, but it also can hamstring intelligence activities. And at many times in our history, including leading up to 9/11, that oversight hamstringing activities contributed to some of the events that occurred. And I'll give you an example. There was nothing in American law that prevented the FBI and the CIA from talking to each other about activities going on inside the United States. However, both sides have been so traumatized by public reporting and internal oversight activities about their relations and how they shared information, that they drew a very bright line to make sure that they did not come close to the laws that prevented activities inside this country. And that caused them not to share information and made us more vulnerable to ultimate attack than we otherwise would have been. We need to be as concerned about oversight stopping illegal, inappropriate, or ill-advised activities, but we also need to be equally concerned about it enabling appropriate legal and advisory activities. So we tend to look at oversight only from one side of the equation, and that's stopping or controlling activities, and not from this other side, and that's enabling and allowing activities. And so I would argue here today that we need to be equally concerned about both sides of the oversight responsibility. And I think we can get into a very spirited discussion on this point during the question and answer, Philip, but I'll turn it back over to you.
I'm quite curious as to what the current state of the wall is. When Ramzi Youssef was being prosecuted for the first World Trade Center bombing, the prosecution went for, I think, 6 years, very carefully not sharing information about his activities with the intelligence agencies, because those were our rules then. What is the state of play now?
Well, I would never pretend to be a lawyer, so I think that's probably, I don't even pretend to be an intelligence officer, but I think that would probably be a better question for Ken. I will say, however, though, that, and this goes back to something else that I mentioned in my comments, the law is one thing, and by the way, different people, different lawyers, and I dealt with hundreds of the lawyers inside of the intelligence community because every organization has many, many lawyers, as Ken noted. Even lawyers disagree on what the law says. So it's the interpretation of the law that matters. And the community tends to be very, very conservative in its interpretation of the law. Now, that's not a bad thing, and I'm not arguing that it should be less conservative. All I'm saying is that we should try to balance that conservatism with the need to conduct activities. Ken, do you want to take on the legal issue?
Sure, happy to. But I think Joan points up a really important point here, which is one of the things you have to watch out for in terms of oversight, for that matter, in terms of putting limitations in place on intelligence operators, is clarity, making it very clear where the line is. Because if there's lack of clarity, then what operators do is, for all the right reasons, they stay as far away from the zone of that line as possible. And what you're talking about here, which was called the wall, proverbially known as the wall, before 9/11, is the best example of that. And just give you a little anecdote about it. It developed, it has to do with the Foreign Intelligence Surveillance Act, FISA, which was passed in 1978, allowed the intelligence community to go to the FISA court to get orders authorizing electronic surveillance. And those orders, some might say they're slightly easier in some ways to get than Title III orders that you'd have to get in order to, if you went to a federal court judge to get authorization to wiretap a criminal suspect. And the concern is that federal prosecutors and agents would try to circumvent the tighter limitations or requirements of Title III and go to the FISA route when they had a weaker case for a wiretap. And in order to prevent that, a set of rules developed that basically said that if the Justice Department is coming to the FISA court to ask for a FISA, the only people involved in that effort have to be intelligence folks on the intelligence side and not on the criminal side, because that would give the FISA court comfort that this FISA application was really to develop to get intelligence and not to get evidence in a criminal case. That, as you can imagine, what does that do? That just reinforce the bifurcation between our intelligence assets in the government and criminal assets. And that's one of the reasons for the wall. And that's why agents, criminal agents, and intelligence agents in the lead up to 9/11 couldn't share information about where Hamza and Midhar were in the U.S. when they were trying to run him down before the attacks. After that, in terms of where the law is now, the Patriot Act, 6 weeks after 9/11, brought the wall down, made it clear that, and I'll get into the details, but that you didn't need to have that wall, that criminal or law enforcement personnel could be involved in an investigation that would involve asking for a FISA order, and that wouldn't undermine the fact that that FISA order or application was for intelligence purposes. And that's what the law is now. So that wall is effectively done, and back to my MI5 argument, that was one of the strongest points we had, was we'd taken the wall down. Why do we want to resurrect it by bifurcating the two aspects of the FBI?
All right, thank you very much. We have about 25 minutes, which is great for this audience. I'll just recognize people if you'll direct your question to someone. Bat Sparrow.
Yeah, question to Brett and Ken. And this is. You need the microphone.
We're recording this, so let's pass the mic around.
A question to Brett and Ken. If you would walk us through, we know that a lot of intelligence operations or intelligence work is contracted to Booz Allen, with whom Edward Snowden was affiliated, and other firms. And I was wondering if you could again walk through how this oversight works with the contracted agencies versus in-house, such as the CIA, FBI, and so forth? I mean, how seamless and how separate are these processes? Thank you.
So I would say on the contracting question, if a particular agency, and Joan could probably speak a little better to this.
Oh, no, I wasn't asked to speak to it, so I'll let you.
They, if they're contracted to an agency, it's still, that agency still has the responsibility and the accountability for whatever the operation may be. So whether it's a Booz Allen or a Lockheed or you name any of the number of the contractors, if they are participating in an operation on behalf, let's say, of the CIA is they're ultimately accountable for their actions. And so any type of proposal and so forth that would require some sort of policy discussion or review, we would obviously, the fact that a contractor is involved may or may not come up in those discussions. If it's particularly novel, it certainly would. But ultimately, we're looking at kind of the agency itself rather than the contractor specifically.
Over here, if you just identify yourself and get a mic. There we go.
Ken, Brett, and Joan, not to leave anybody out. Ken, can you just talk a little bit? It's been 11 years since the MI5 proposal died at an NSC meeting. Can you just describe some of the reforms and operational capabilities in terms of enhanced operational activities of the FBI that has taken place in the past 11 years? Give people a sense of how we have not only taken down the wall, but we have better coordination. We can better connect the dots today in terms of the JGTFs and NCTC and all that went on and still is going on today that's improving our operational capability.
Yeah, that's a great question. And Joel, you were a large part of this, your time at the NSC, because this was driven from the top, no question about it. And look, I think to get to the end of the book, the FBI, my assessment, and actually there was a 10-year assessment, after the 9/11 Commission that just wound up, I think, about a year ago, in terms of how far the FBI has come in developing itself as an intelligence agency. It's still a work in progress, and I'm sure Jim Comey would say that and has said that. But I think they've made, when you look at the strides that have been made by the Bureau and also by the rest of the intelligence community to use the Bureau effectively and use that capability I talked about, the joint intelligence law enforcement capability, come sort of bureaucratic, in bureaucratic terms, they've come light years. And there are a number of reasons for that. One, as I said at the beginning, this was driven from the top down. As you remember, President Bush had the AG and the FBI director and the CIA director, in his office 6 days a week about counterterrorism. And that was to get him briefed, but also to push change. And that was happening. And, it was, you talk about information sharing. I remember the stories, if somebody in that meeting had some information for the president, hadn't shared it with his or her counterpart in the intelligence community or in the FBI, wouldn't want to be that person. So that was being driven from the top, and the NSC, of course, echoed that. But then within the Bureau itself, they've done, there are countless reports about this, but everything from the training I talked about earlier, really to try to develop a cadre of agents who understand what intelligence collection is as opposed to just evidence collection. They now have analysts. Back when I was working with the FBI in the 90s, there's one analyst for oodles of agents. Now you have an analyst corps, and they're learning a lot from the CIA and the rest of the intelligence community about how to analyze information and make it actionable intelligence and report it out. There's just NCTC and all the different mechanisms that ensure that there's sharing between the FBI and the other parts of the intelligence community, and importantly, within the FBI. And one of the problems in the FBI is it used to be 56 separate field offices, and every matter was assigned to a field office. When 9/11 happened, Mueller took the unprecedented step of making the 9/11 case a national case. And that was a big step, and that effort to try to harmonize the intelligence collection and law enforcement efforts, especially in the counterterrorism area of all the 56 field offices, that has accelerated. It's also accelerated with their ability to now, they have an IT structure in place that allows for that, which they didn't for years. So, work in progress, but I think they've made great strides.
Admiral Inman.
Thank there's an element on the sharing or not sharing that I not heard you surface, and that relates to discovery in prosecutions. And certainly my experience, very painful, was information we provided to the FBI, which became involved in prosecutions, released in this process. It reached a stage where our British colleagues told us they weren't going to share information with us anymore unless we could prevent that occurring. So we simply stamped everything property of Her Majesty's government that we sent across the service. So it was a real challenge, that and what came out under the Freedom of Information Act. So it wasn't just a reluctance to share to hold on to power, it was the real worry that what you shared was going to get released.
It's a very good point. Comment on this from the panel?
Yeah, that has consistently been a big concern. I will tell you, though, that I think the courts have become very sensitized to this issue and are protective of classified information a lot better than it used to be. Again, not trying to practice law, and Ken may have a different perspective, but I actually think we've figured out a pretty good balance between the need to protect the information, but also to prosecute where necessary. And I'm not aware of any major issues in the last few years over this. Brett or Ken, anything different to that?
A very important issue, and one that's become more important post 9/11, where you have the sharing of information, and also you're using prosecution as a part of the overall intelligence preventive effort, which, especially when you're looking at cell members in the United States, since we can't just vaporize them, we have to do something with them. What do? We prosecute them typically. So being a big issue, a couple answers. One, the courts, as Joan says, the Classified Information Procedures Act, which was passed, I want to say 1981-ish or something, and it was in 80? Yeah. Oh, there you go. So, as you know, it provides a construct by which federal courts can assess whether sensitive information, classified information, can be shielded from view through the court process. Courts have gotten better at using that, and frankly, the Justice Department has gotten better at using it now. So, for instance, when the CIA General Counsel and the FBI or General Counsel, or more likely the head of the National Security Division, sit down and talk about intelligence that could be used as evidence in a criminal case and whether to use it for that, and therefore whether to bring the case, they have some sense of predictability. Okay, well, this source's name, that can't get out. He's still in place. We cannot let that get out. Well, we think, based on the case law and the prior use of SEPA, the judge will agree that it won't get out. And that predictability allows more intelligent and knowing decisions at the front end. And then the second piece that I think has improved a lot is just the interaction. I was on the phone, head of NSD, and then when I was at GC at FBI, all the time with the CIA General Counsel. And so part of the integration and the lowering of the wall has meant we have a better, more regular relationship. And so that just fosters sort of greater confidence that we're going to handle the information the right way.
We have about 15 minutes left for questions.
I will also say, Bob, that I think the community's gotten a lot better about, rather than classifying for convenience, classify based on what is discernible, not based on what we know. And so I think that has helped this process as well.
Yes, ma'am, over here.
This is a question for Ms. Dempsey. You mentioned that oversight should enable operations or can enable operations. Are there specific suggestions that you would have about things that we need to do more of to achieve that goal of enabling operations through oversight?
Yeah, I don't know that there are specific suggestions. I think it's as much a cultural issue as it is an activity-based issue. I think that every time there is an investigation and a media swirl around some activity, that causes antibodies to build up inside the intelligence community, and it goes overboard at trying to prevent the swirl, not necessarily improve activities, although that is always a concern. the point I'm making is that sometimes the sensationalism of the results of oversight cause the community to become more conservative. So how we achieve a balance, obviously we need oversight. We have to have both the rule of law, ethical and appropriate behavior, but we don't want to have the community take the wrong lessons from controversy. We want them to take the right lessons. So again, it's more cultural than it is a particular activity, I think.
I would just add on to what Joan said and something Ken said earlier in terms of policymakers providing the clarity to the intelligence community up front in terms of what the guidelines are, what the policy red lines may be, and then, frankly, leaving it to those agencies to kind of operationalize, if you will, that policy guidance, and coming back, always having an option to come back to the White House, to the NSC with questions and further guidance. But the clarity is something I think, even as a policymaker, it's something that we can always improve on.
Yes, sir.
Good morning. Thank you. My question is for Mr. Holmgren at the NSC. If you could explain the process of this White House and the deliberation that goes on with regard to a covert action, is the decision made to brief then or to provide CIA with the approval to brief HIPSI, CISI, and the appropriate oversight entities? How is that deliberation made within the White House on the timing in terms of compartmentation, keeping the information secure and safe, and the sanctity of the operation with the responsibility and need to brief oversight?
So I'll be somewhat circumspect in how I answer this, but look, obviously with the covert action, the findings and any updates to those findings are always briefed quickly to the oversight committees. If there are specific operations conducted under a finding, those are always sort of briefed to the oversight committees, generally within a very short period of time. After they have occurred, there will be occasions when there may be an advance notice, if it's particularly novel or a reason that we feel that the Congress should be informed in advance. But we're also very circumspect to preserve I think the necessary secrecy around some of these very sensitive operational details where, frankly, officers' lives can be at risk in the event that any of this is revealed publicly. So I would say it's a case-by-case basis in terms of those operational notifications, but certainly for the broad findings, any updates to those findings, the Congress is always kept fully and currently informed.
Great job.
Yes, ma'am.
Hi, this is for Ms. Dempsey. I wanted first to thank you again for meeting with me yesterday. You answered a lot of my questions. But as the PAB is specifically an important part of executive oversight, yesterday you mentioned that you thought it would be most effective for the board to be comprised of knowledgeable generalists as well as intelligence professionals to have that knowledge base. But I was wondering, assuming that the board remains the way it is now, without current intelligence practitioners or government employees, what do you think is what needs to change to ensure that the most qualified people are appointed to the PAB? And should there be set criteria for potential members that they must meet to be chosen?
Yeah, Darby, so right now the chairman of the PAB, the President's Intelligence Advisory Board, is a former intelligence professional and a superb one at that. The board, though, is challenged, and it's challenged for a number of reasons. One, it is comprised of political appointees. That process in itself is very challenging, and I've worked for 6 different presidents. None of them came into office with a slate of candidates that they wanted for the PIFIAB or now the PAB. And so they develop that slate after they're elected, and then those individuals, if they don't have one already, have to get security clearances, and they have to go through the political confirmation process. And all of that can take a year or more. So you're waiting to get your board up and running. And then the board itself typically is comprised of mostly private citizens who don't have a lot of experience in intelligence activities or any experience. But even if the board has a mix of former practitioners and private citizens, it's still a very slow process to get started. And then the PIAB itself has a very small staff, 3 or 4 professional staff people who support the board and interface with the intelligence community. I have absolutely zero hope of this happening, but I think it would be much better to treat the PIAB in similar to the way we treat ambassadors, where you have a mix of State Department employees who are ambassadors, usually to all the garden spots, and then you have a mix of political appointees who come in and hold ambassadorships in other countries, and that way you have some continuity, particularly in areas where you really need it, from one administration to another, but you also bring in people from the outside who are vital, in this case from an intelligence perspective, in bringing different business practices, different ways of thinking about intelligence from an oversight perspective. So I'd love to see the board made up of term appointments, people who transition or stay with the board across the transition from one administration to another, as well as political appointees. Now that would create its own challenges, but I think those challenges are manageable, and it would provide for continuous oversight from a White House perspective. But again, I have zero hope of that happening.
Admiral Inman.
I'm not going to like this,
on
I'm
this
sure,
question.
Bob.
You are going to be happy with this. Just a little bit of history of a time when it was a much more experienced, competent board. Depends on the president.
Yes.
President Carter disestablished the PFIB on the recommendation of Stansfield Turner,
Right.
coming as a DCI for the history. President George H.W. Bush was reluctant to recreate it, but chairman of the Senate Foreign Relations Intelligence Committee, David Boren, said, if you don't recreate it, I'm going to do it by legislation. So it was a small group, just 6, John Tower, who then was killed in an accident, Inman, Lou Allen, who'd been my predecessor at NSA, Chief Staff of the Air Force,
Right.
John Deutsch from MIT, later at CIA, Bill Perry, later Secretary of Defense, and John Hyland. So it was a very experienced group. There were no real political figures in it. My point here is it's the president. And the president's knowledge of it and whom he selects to put in, I would argue, more than a term
Yeah.
factor.
I don't disagree with that. But at least if there were term limits for some number of the board, you could have that continuity that we don't have today.
More questions? Yes, sir. Right in the middle. Right.
Thank you, sir. I'm Steve Bracken. I'm a graduate student in the PRP here. So my question is to Mr. Holmgren, and it's there's not much in the literature about the current supervisory role of the NSC for ongoing intelligence programs. Can you describe to us what, to the extent you can, what is that supervisory process? How often do you bring those programs, back in front of you and question the effectiveness and whether you continue those programs? If you could just elaborate on that, appreciate it.
Sure. Thanks for the question. Executive Order 12333 does prescribe kind of a fundamental role for the NSC in terms of conducting oversight of covert action and intelligence activities. So, in terms of the regularity of it, again, a lot of times it's going to be driven by operational needs. Having said that, there are some standing things that will move to us every couple of months for sensitive military operations and certain schedules that require presidential approval. There will be routine requests, whether they're FISA requests that require sort of a National Security Council, National Security Advisor review of certain things if they have diplomatic implications. And then obviously for covert action, it will really depend on if there is in a finding, if there is a request or if there's a requirement, I shall say, for a particular notification to the National Security Council in advance of that, those will come in and we will work those through the interagency process as required, as appropriate. And of course, it all depends on whatever the timing and the requirements are for the operation. But sort of a roundabout answer, but it honestly, it really sort of depends on the particular kind of operation or the particular issue. Having said that, of course, there are the standing things that will come in every couple of months.
All right, we've got just about 4 minutes left, 5 minutes perhaps. More questions?
I don't want to hog the floor.
No, please.
What I want to get the panel to focus on is the changing atmosphere when what we were concerned with after Church and Pike Committee was legality of activities, primarily in the U.S. And we were focused on foreign intelligence collection inside the U.S. and on counterintelligence. And then came 9/11. And suddenly technology had driven you with the moved packet switching, but more importantly, looking for individuals inside the U.S. who might be involved. So I'd make the case to you that we had an era from the late 70s to early 2000s when the focus in the oversight was primarily on creating laws, executive orders, laws, to provide guidelines. And then suddenly a whole shift when counterterrorism became the factor and a whole different set of targets.
You know, I'd like to sort of add a footnote to that question, and that is, what will the inclusion of protections for foreign nationals that the White House has announced, what sort of impact will that have? Brett, you want to start with this?
Sure. So, and you're referring to I think the unprecedented step that we took in the wake of some of the disclosures as we put together the signals intelligence reforms codified in Presidential Policy Directive 28, which does provide privacy protections for non-U.S. citizens concerning intelligence collection, which is unprecedented throughout the world. Look, the agencies are working through the guidelines that have been established. They're, as they always do, are committed and dedicated and are working hard to apply those in terms of what the operational impacts are. But I certainly have confidence they're going to, and currently they are going to be able to succeed and to continue to do what they need to do. But I think the broader question that the Admiral raised, though, is in terms of, the shift and the focus on oversight today is much more on foreign intelligence collection, and I think it's really been highlighted in the last couple of years in terms of the impacts that certain intelligence activities can have on our diplomatic relationships, but also not just our diplomatic relationships, our law enforcement, our intelligence relationships with a lot of these countries. And so what we have tried to do to strengthen some of the oversight is to be as transparent as we possibly can while protecting the operational requirements, to share more about not only what the process looks like, but actually what safeguards are built in place, and also the various protections that are extended not only to Americans but to non-U.S. citizens as well. So I think that will continue to be a challenge going forward as the world is interconnected, and the growth of technology, and there is a demand not only from the American public but from other publics for privacy protections generally, and I think suspicion of U.S. intelligence activities more specifically. So I think it's, to my point earlier in the opening comments about how I think we'll need to continue to evolve our oversight structures to kind of keep pace with the world and to keep pace with the intelligence community and the skills that they're developing. I think it is something that we're going to have to continue to confront and think about smart ways to address it going forward. But
Last remarks, Ken?
Just,
When you're done, sorry.
okay. And I think this sort of helps pave the way for the next panels that are coming up. You're right. The question is that construct that was put in place in the 70s, you know, at least was the construction of which started in the 70s, is it really still well suited to today? I don't know, though, that I'd say that 9/11 was the turning point that really raised that tension, sort of historical tension between today's circumstances and the circumstances that apparatus was intended to address. I think actually the Snowden disclosures was really the more important break point in some ways, in two ways. And it raised two questions about the construct we're working under. One, you know, legislation through the intelligence committees, where they handle things in a classified environment and then make recommendations that end up in legislation like we saw in 215 and other things. Does that still work? You know, given the public's questions about some of that legislation and its use by the intelligence community, does that work? There's that fundamental tension there between, you know, maintaining secrecy where needed, but also making sure that Congress has oversight and legislates these authorities. That's one thing that was pointed up in the wake of the Snowden disclosures. And the other, and I think Brett alluded to this, is, you know, the question of oversight not being just, as you said, is something legal or illegal, but is it something that we should do as a matter of risk? And that contemplates a completely different analysis, really. It's, you know, yeah, we can do this, but is this something that is worth the candle in terms of the diplomatic blowback if it gets disclosed, like the, you know, wiretapping foreign leaders' cell phones? Is it, you know, while it's legal, is the incursion into privacy justified by the benefits? That kind of oversight. And I think we're struggling right now with, you know, was that in place sufficiently, you know, before? It's a really policy question. And what's the best way to making sure that that question is asked today?
Joan, do you want to?
I'll just say
Final.
that I think you made the point that I was making in my opening comments, that we build up a system and a process based on the last issue. And the last issue in Church and Pike was domestic surveillance, and that influenced exactly what happened at 9/11. We've now built up processes and a system that deals with what happened on 9/11. Does it preclude us dealing with what comes next? And that is the issue. It's not about mitigating risk so much as it is about managing risk. So,
I think that's a good place to finish. I think we could have looked at the wall before 9/11 and thought that something like 9/11 might happen. So you have to ask yourself now, when we get hit the next time, what is it we're doing now that we're going to have second thoughts about? I want to thank our panel for coming. I'll thank the University of Texas for asking us. Steve, you had a...
No, that's fine. That's good.
Thank you all for coming.